your principal duty, I think, here is to the individual who's come to you and given you this information. You owe them a duty to protect them, to direct them to EAP, to work with them, maybe to say, okay, we need to get you some counselling, some support, and then I'm going to ask you again tomorrow, about the need to develop a process to address this workplace hazard. And if we're not ready tomorrow, then the next day. So you owe that person that duty. But past a certain threshold, it becomes a hazard that you have an obligation to deal with under the Health and Safety at Work Act. Section 7 of the Privacy Act means that the Privacy Act is subordinate to legal duties owed under other legislation. So once you pass that threshold, I think your duty is set out in that health and safety legislation. There's also, even if we don't quite get to that threshold, and I'll be interested in Greg's thoughts on this, your obligations to not use or disclose personal information are limited, aren't they, to exceptions. So it is not a breach of the principle, thou shalt not disclose, thou shalt not use the information, where you believe on reasonable grounds it's necessary to do so to avoid to avoid harm to somebody. And it may be that in order to avoid harm to that employee or others, you need to disclose their personal information despite the fact that they've asked you not to. When I was in practice, I used to get this from time to time. And my approach with clients, if it wasn't a really serious, immediate intervention required kind of thing, was to talk to the employer about notifying universally all staff what the expected standards of conduct are. Or I have been told that we're slipping in areas of culturally appropriate language or physical contact. Everybody should know this is a safe workplace. So rather than targeting the individual, broadcasting your message, that makes everyone feel safe, but you've still done something to address the issue. The principal point here, and I think it's important to pick up on the question that came from the second row. It's not an uncommon misconception. Hang on, we were talking about principle of you're not allowed to disclose things to people. Actually, here we're talking about an individual exercising their right under Principle 6 to access their own information. They're saying, empty your pockets, give me everything you've got about me. Now, somewhere there's a document which has never been disclosed to that person because somebody vented and got something off their chest or found their way into EAP or tried to escape the consequences of poor performance, which sometimes happens as well, and it hasn't gone anywhere. The starting question for assessing Greg's scenario is this personal information about the person requesting it? To the extent that it is, your starting point is they have a right of access to it. Now, there's a number of reasons in the Act. We come out of the principles. We look in section 27, 28, 29. These have reasons for refusing your access to your information. This is what we're talking about now. One of them is where the disclosure would involve the unwarranted disclosure of the affairs of another person. Now, I think this is where Greg has cleverly tweaked his scenario a couple of times, because there's a lot of weight in those different words. First, is it personal information about you? Well, Greg bullied me at work, and I was so upset and distressed that it affected my mental health. I couldn't sleep at night. I began weeping uncontrollably. This is information about Greg. But it's also very intimate information about me. So some of it Greg might be entitled to, some of it we might be entitled to withhold. A really important question, which I think reflects the tweak Greg gave, is this unwarranted. If you intend to act on the basis of this information in a way that is detrimental to Greg, it's still information about him, it's still disclosure of my personal affairs, but we might err more on the side of disclosing to Greg on the basis that that disclosure is warranted. So it's impossible. There's so many variations, so many different ways information might be recorded, so many different scenarios, the effects of time, how old is this, are the parties still around? what do they think about it, you can consult with them. That we can't give a hard and fast answer. You've got to assess it with reference to those statutory tests. Is it about the person making the request? If so, is there anything in it that would involve the unwarranted disclosure of the affairs of that person? If we had the scenario from earlier about the really harmful bullying, there might even be a risk that disclosure could endanger that person's physical or mental health. Yes, of course you can.
Yep.
I mean, that's an accurate record of the thing. As you know, Principle 7 says anyone can exercise their right of access to the information. Once having done that, they can ask for any incorrect information to be corrected. If you don't agree, then they can ask that you attach to the disputed information a statement of the correction that they have requested but you've not made. So the disputed information is always read with the other information. So what they might say is, okay, then on reflection I accept your assurance that it's an accurate transcript, but it's out of context. Or, you know, that sentence doesn't make sense without this extra bit that I was thinking about overnight. And then, yes, you would have to attach the statement, but you don't cross out and doctor the original, which is an accurate record, based on their assertion.